Buenas tardes, bienvenidos
Good
todos
afternoon. Welcome to everyone to this diplomat degree in the University of Arizona, and especially Justice Juan Luis Gonzalez Alcantara and Dr. Fernando Sosa. Welcome to the University of Arizona. We will allow Dr. Vega to make a brief introduction.
Those who need a translation, please choose in the interpretation.
And those who need interpretation, go to the link in the bottom and go to German, which will be in English. And afterwards, we will be switching interpretation. The interpreter shall tell you when to switch to the English channel. So if you'd like to listen to the session in English, choose at this point the German channel. Thank you very much, Ruben. I just briefly want to mention and thank you very sincerely, especially Dean Mark Miller, Teresa, and Ruben for continuing with this diplomat that for our UNAM university is very important. This is one of the first diplomats in Mexico in conjunction with the university in the US and in Spanish, which makes us very happy because this demonstrates not only the interest in our judicial system, but also the interest that you have in judicial issues in both countries. And this is very important. So thank you very much to University of Arizona College of Law. I also want to thank Justice Juan Luis Gonzalez Alcantara, who's fortunately part of the UNAM law school, but also now is a justice. And I know that a big part of your heart is in academics. And whenever I can, I like to invite you to events and activities such as this. Therefore, it's a great honor that you are here in spite of your busy schedule, and that way are able to share with your experience in your area of expertise. And again, Fernando, back to you. Thank you, Juan. Now, Dean Miller will also provide a welcome to our guests.
A very brief welcome, but it's
Una
great,
bienvenida.
great to see you all.
Muy
We would not have the
breve. Qué bueno
Diplomado
verlos a todos. No tendríamos un diplomado
if it was not for Dr. Vega,
si no fuera por el doctor Vega,
the leadership and support of Dr.
el
Salazar,
liderazgo, el apoyo del doctor Salazar,
and a commitment to explore a new idea, a new partnership for two institutions that have worked together for a very long time. I just want to add my welcome to Justice Gonzalez. It's illustrative of the amazing backgrounds and intellectual and policy perspectives that have been shared through this Diplomado and these classes. And let me just add my thanks to my colleagues, Chris Gass, Teresa McGill-Stearns, Kathy Barnes, and Amanda Wolf. It takes partners on both sides to do this. Welcome all.
Gracias, Dean Miller. Thank you, Dean Miller. And so we will vamos a dar la bienvenida.
So now we will formally welcome Justice Juan Luis Gonzalez Alcantara and give you a brief overview of Justice Alcantara, who is a member of the Supreme Court in Mexico, which is the highest court in Mexico. He's been a justice since 2018. He's graduated from UNAM in law with public finance expertise and international law as well, and also a master's degree in from the Autonomous University of Barcelona. He's also an honorary investigator of the Judicial Investigation Institute. He was also part of the group of people who redacted the Constitution in Mexico City. I think we studied this about a year ago. And he's been a director of the Anagua University Law School. He was a judge and magistrate of the Mexico City Justice Court. He will talk today to us along with Dr. Fernando Sosa, which is a coordinator for Justice Alcantara in regards to the amparo system that is very important in Mexican law. Dr. Fernando Sosa, as I mentioned, is a coordinator for Gonzalez Alcantara, Justice Gonzalez Alcantara. He's also an attorney, having studied at the Salamanca University in Spain, and also a master's in law with University of UNAM. He is also an academic and a researcher at the Humanitas University, and likewise part of the Judicial Investigations Institute, and has made presentations in different universities in Mexico. He is also has written many articles in regarding to law. Welcome to the University of Arizona, to the James E. Rogers College of Law. We're very happy to have you here, and it's a great honor to have you all here. So now, Dr. Fernando Sosa, who will also provide an introduction. Welcome again. Thank you very much. I am very happy to have this opportunity to talk to all of you and to share a bit of what we understand about the concept of amparo. Before speaking and preparing for this amparo, how it's seen in Mexican, this law. This procedure is a very complicated, and this is basically a procedure that is not subject to the understanding of common folks. This is something that is very technically complex. And of course, there's a lot of discussion and various different courts and different folks and how to apply these rules. And personally speaking, this has to do with a perspective that we have in Latin America to study this amparo procedure and just to see these rules as to how this came about, when it can be applied and when not. Because, for example, in Argentina, this is a system of constitutional protections that has a technicality that is so complex that it makes it into a very excessive formalization. I don't want to criticize the amparo procedure, but speaking in context and what we are talking about. So within this, having a dialogue with other people and other jurisdictions would help to see how the amparo procedure has had a very particular meaning in the construction and the buildup of our judicial system in our country, and how it has accompanied this transition that, at least during these last 20 years, has been seen more and more in Mexico, a transition from a legislative state to a constitutional state. The amparo procedure, aside from its consequences, procedural consequences, is very important in the transition from a legislative state to a constitutional state in Mexico. And also, of course, it has created, from a cultural perspective of what law is, how this has molded the understanding of constitutional law and its coexistence with ordinary law, and how it has taken power within the courts and local jurisdiction courts, and compared to the Mexican constitutional courts. In the amparo procedure, it's a control resource, a constitutional control that allows citizens basically to be able to, through actions or omissions, be able to protest before authorities. Maybe there are, through this resource, they could argue that an act that would, by omission or action, in prejudice to a citizen and in a collective system, how it could affect them. And of course, I don't want to go too deep into this and talk mostly about the history of the amparo procedure. But so we would say there's a division in types of amparo: direct and indirect amparo. Direct is against the authority that would not constitute the last resolution of what would happen. And this is the only way that this could be done. Say the detention of someone for a DUI. This could generate something that could maybe not be restored later on. And then we have an amparo also, where this resolution could affect basic rights, international treaties, etc. That is the direct amparo. Logically speaking, the different organizations that would be in charge would be two: the district judges that know about these direct amparos against authorities, and other courts that are in charge of these direct amparos. This is a very generalized explanation that, of course, doesn't talk about other forms of amparo and other resources. Amparos has many principles that would not allow for others to go to other courts, but all our authorities in our country are subject to this constitutional control, and this has a very important, is very important for them, because they see how any act can affect them. So ideologically speaking, the cornerstone is that the amparo is the main figure of building a constitutional control. And historically speaking, it's very important for us to distinguish. While in other countries, there was a diffuse control, meaning that these jurisdictional rules of judges and courts are federal. They belong to the federation. Of course, there are local level courts for each state and for the republic. So for a long time, the perspective as to who could define what the Constitution means and what it states basically would derive from this great principle of constitutional control, which is amparo. And why? Because in spite of our Constitution having, or it hasn't been reformed yet, a clause that which would indicate that the courts and at a local level and at a federal level can basically, when they would see that these norms are contrary to the Constitution, and this comes from the first Constitution, the Supreme Court itself and many of their opinions considered that these local level courts could not provide this constitutionality control because they would consider that every law had a principle of presumption of constitutionality. And this principle of could only be destroyed by those courts that would have to analyze these norms. So although the Constitution had the possibility of the local courts being able to contrast between what their local rules and laws within different states, Chiapas, Oaxaca, Guerrero, the court in its interpretation constantly opined that they could not provide this control of constitutionality. So the premise was that the presumption of legality of these legislative laws could not be destroyed by other competent courts. So what the Supreme Court did was to concentrate the constitutional revision basically within the courts that would solve these amparos. So there are other constitutional control means, but these are abstract. We're talking about amparo, whereas they become close to our citizenship. And so in our country, there was a consequence where we started thinking that local level courts did not have a direct dialogue with the Mexican Constitution, that the local judges and courts were judges who extremely applied this legality. So they had, the amparo became very strong because, and we're going to paraphrase Peter Haberle, saying it's a closed society for those who interpret the Constitution. So the Supreme Court interpreted and opined, speaking in the past, that only those who could interpret the Constitution could make these decisions. And what they did is took over this constitutional interpretation for federal judges. And us, through amparo, could interpret the Constitution in a valid manner. So this is very important. And so now we can see this differently. We can find this in the US, where the local courts, aside from the Supreme Court, have a constitutional interpretation of what the law is, and they concentrate most of their cases within this. So this is a historic panorama of what our Constitution is. But I'm talking about before 2011, so we don't go far back in history. And in spite of this, culturally speaking, people were finding only within federal judges and courts through amparo, they could interpret this, our Constitution in regards to this premise. So one of this interpretation that became a precedent, an obligatory precedent, had to do with a justice who had died, Justice Gudiño, and that's what he states. The diffuse control is not authorized for those local courts. Why? Because amparo then, aside from its Mexican sui generis structure, has a power, a central power, and basically took over the discourse as to how we would be able to interpret our Constitution when some individual would feel that they were affected. So this is a concentration that assimilated amparo and reduced the role of local courts within this dialogue that would be necessary. So this was what the state of what we did until there was a reform in 2011 in the Constitution and the compliance of the Radilla Pacheco case, when we started looking as to how we needed to understand our constitutional system. And the courts basically, and I'd like to also share this because the justice as myself before being members of the Supreme Court, we also were like what you would consider judicial clerks at a local level, and as well as the justice as an appeals judge at a local level as well. So only federal powers or the federal judicial power had the control as what Constitution is. But when it came to compliance of this Radia Pacheco case and the human rights reform, which stated that every authority within their courts would have to guarantee human rights. And in the Radia Pacheco case, we start analyzing what is the control of Mexican constitutionality. And they switch their chip, as we can say, and we reinforce this with a different precedent, which is Rule 293, which creates the constitutional doctrines, so restructuring. So then this becomes more important as within our local courts to state what is the Constitution. These are parts of a more open society where they can interpret the Constitution and being able to analyze if a law can be interpreted more favorably towards constitutional principles and human rights, and also to not apply a law if this would be contrary to this case or to a constitutional principle. So through this reform, we began seeing a more dynamic way of handling this, starting in 2011, where local judges and courts also had a participation. And understanding our cultural perspective of law is that the amparo was the means by which citizens could, in a valid way, have a constitutional interpretation. So amparo becomes the main provider of constitutional ideological thinking in this country, aside from the abstract actions that came later in the 1994 reform, which are actions and controversies. And then where our Supreme Court becomes stronger and becomes a constitutional court. Amparo has a great impact for citizens, for courts, and it began a ideological perspective as to what you can expect from a local level court in relation to federal judges. So this is important because this would explain why amparo became so strong and why amparo is so present in our judicial system, and how some of the interpretations remained outside of the scope, interpretations of the local level courts. So amparo becomes an ideological bastion of our judicial system. It's important to state this because the interpretation as to why local judges couldn't interpret the Constitution, and we would have to provide the federal organisms or organizations this. So in collectively speaking, within this cultural perspective, the relative part of what local courts could do, say district courts, etc., which were created later. So this would make a difference. It would be very different to what has happened in other countries, because amparo was placed as a means of concentrating constitutional interpretation. This would explain, and this is something that I want to connect to historical terms, and maybe Dr. Vega can correct me. He's a great jurist and someone that I respect, and if there's something to be corrected, he will do so. But I just wanted to place this in a cultural context, which is very important to understand, because within these last years, this evolution that we've had has become very clear, where we have a legislative state where the buildup of these laws had, from a legislative perspective, to a constitutional state, where within the discourse of what we understand as what is a constitution, This is not only an ordinary of constitutional control as the amparo, but we have a more constant interpretation from the federal entities. We shall now go to the English channel, please.
And if there is any question about what I am saying, I can, or I can explain more. Does anyone have any questions or comments or anything for me to, that I need to explain more, or anything that I omitted or that wasn't, I didn't flush out enough? Of course, amparo, in the role it has in the Mexican culture, has also moved the thought of Mexico and the Constitution, because through different forms in the Mexican courts, it has dealt with relevant issues, and we can see how also the way that we have protected institutions and how these have evolved is completely connected to the amparo procedure. And why is that? Well, because up until 1994, the main constitutional control means or interpretation was amparo. After 94, there were the controversies that were that had a much more wider scope. So much of the amparo in the Mexican courts allows us to appreciate how we have evolved or progressed in our understanding of our institutions, in our understanding of rights and constitutional rights in throughout time. We can understand how the legislative state was very consistent in our country. For example, an example of how we evolved in our ideology, one of the things that Dr. Gonzalez Alcantara is going to explain how amparo has been adapted to have a maximum scope in very complicated issues such as the rights of cultural, economic rights, indigenous issues that were not that finely honed in our jurisdiction. Amparo is kind of a thermometer of ideological concentration, and it explained the thinking of our judges 50 or 60 years ago, and a 20 years ago, for instance, the courts would have much more wider horizons and thought, and that, of course, has had consequences. The importance of the legislators started eroding with a court that started having controls of constitutionality in courts that appreciated fundamental rights. I will give you historical examples. Just like in the United States, legal precedent is very useful to understand how the thinking in the U.S. Supreme Court has evolved. We have cases that have paradigmatic breaks, for instance, when they like separate but equal, when that was overruled. You could see the evolution of the constitutional thought. In Mexico, there was that thought, but it wasn't as closely followed in academia. One example of how amparo, being an historical constitutional control, did keep the status quo on the legislative state. We can think, what did Mexico have in common in terms of ideology in 1929, 30, 31, 32, 36, with Nazi Germany, for instance? And I'm mentioning this just to see how the thought has evolved. A couple of days ago was the Holocaust Remembrance Day from Nazi Germany and the concentration camps. This is something that should never be repeated. It was the crime of crimes. What role did Mexico play in this? Obviously, we were not directly involved, but it is important to see how ideologically, just like the U.S. Supreme Court, in the opinion that Michael J. Sandel mentions in his writing about against the eugenics and ethics of perfection, Mexico did have norms that were going along those lines, and they had with a legislative perspective. For instance, there's direct amparo from 1848 to 1920. This amparo happens in the context of Asian migration into Mexico. In the late 19th century, um, Chinese people started immigrating and populating our country. Porfirio Diaz, as some of us will remember, at the end of the 19th century, signs the Commerce Treaty between Mexico and China. And then in Baja California and in Sonora, especially, there was Chinese population. Um, this had an effect in Mexico that sadly is not really remembered so clearly, and it created a distance or alienation towards this Asiatic population that was arriving in Mexico. So there were settlements, and they were pretty consistent. And what happened around December 1923, the Sonora Congress, Northern State, passed law number 31, where expressly it prohibited to marry a, a man, and literally a Chinese man could not marry a Mexican woman. Interracial couples were affected because it's an interesting aspect because there was a different in genotype difference. It made a distinction between racial genotypes, and there was a distinction for the feminine gender, meaning the people who could not marry the Chinese people were women. That did not apply to men. Check it out. So, and then several cases went to court. The one that went to the Supreme Court in Mexico is the Carlos Wang Sung, who was a citizen of Chinese origin born in Sonora who tried to marry a lady named Juana Ramirez, a Mexican citizen. His petition to marry her was denied because of the law that I just mentioned. So Wang went on amparo. He brought forth an action on violation of fundamental rights. The court argued that this law affected several contents of our Constitution, 1, 3, 14, etc. But especially the principle that every resident in Mexico would have the rights that are now called fundamental rights, meaning they were not talking about people being suspicious, uh, but he started arguing that he was not enjoying the same rights as that every resident should have, and that the Constitution guarantees that to all the residents. The district judge who heard the first case thought that his arguments shouldn't be overruled. The judge thought that the way that marriage was regulated in the Constitution was something that was the subject of states alone to decide. What is he saying? The federal judge who heard the case said the way that marriage is regulated is a matter for the states to decide. So the court also on this constitutional issue results in a very interesting issue because it took 3 years for the case to resolve, and it shows how our courts back then were overlooked. Why? Because there were no intermediate entities. It was the judge, and from the judge, it went directly to the Supreme Court. There were no intermediate courts like the collegiate courts right now, the courts of appeals. So the case took 3 years, and in December 1932, the Division Two of the Supreme Court unanimously voted, and they denied amparo. What does that mean? They ruled that he was not right. This was presented or by Justice Valencia, who stated that marriage is a civil contract and therefore Sonora had plain white sovereignty to rule on this issue. Also, this meant that that figure was not an individual right, meaning marriage is not a right, and that the restriction simply was an impediment uh, to celebrate, to enter into marriage. It is very important to see how, in this case, even though Amparo was a constitutional system, it's still there was still a ideological interpretation of it, and it kind of deferred to the legislators. In fact, the justice said it's not an affirmative um, rule. It does not affect you only, but everyone who is Chinese, and that's just a requirement of marriage. That is important because that has to do with that bans interracial marriage, and it happened before. It happened in Nazi Germany, which happened in 1936, I believe. Inga Mueller, in The Jurist of Horror, explains that path. They found a path with prescribed interracial marriage. My point is that they held this vision that the state would have a legislative outlook. In family law, we see this evolution more clearly. Another amparo is one from 1977, where a lady is exhausted from her family dynamics, and she feels that she no longer 663055. And this lady is exhausted, thinking that her marriage it wasn't optimal for her anymore, and her relationship was devoid of mutual love. And the Court Supreme said that love is a fundamental right for element for marriage. Um, and this marriage could exceptionally be dissolved. So Amparo is a thermometer of how we understand the Constitution in our country. The other side of what the court has ruled over time, it has ruled strengthening our rights occasionally, and it has decided how we understand these issues. This perspective has seen how Amparo had a role in our legal system. Why am I saying that Amparo also evolved with our vision? Currently, the Mexican courts have lots of precedent thinking that element is a fundamental institution for a family. Family is not rooted on legislation, but it is a wide concept that family should prevail on any form, even if it's not expressly described within the legislation. The local legislation, in spite of them having great authority, or they defer to legislative, should act on principle. The way that Mexican court now understands marriage is more, is closer to fundamental rights than to the legislation. This change is due uh, especially to Amparo. Amparo has allowed the destruction of dynamic concepts of man and woman as a couple, and has been able to expand it to just two people. Amparo has allowed to consider that this old-fashioned idea that there should be reasons for a divorce is in fact changed to divorce at any time, because otherwise it would run against the free development of the people and their ability to have their own life. The court also ruled that some laws barring the courts that said that divorce could only be applied for after 1 year of marriage, that rule really runs contrary to the personal development of humans. To a great extent, amparo, even though that in many regards is still like 19th century understanding, it was like a constitutional appeal on principles that concentrated the interpretation to the federal courts, is really the great builder of precedent that has changed institution. So in a way, amparo is a good thermometer, a good meter to see that Mexico has gone from a legislative state that came from legislation as the main source uh, versus it has changed to a constitutional state to where everything, all the legislation should be under human rights and constitutional rights. So we have seen how many institutions have been completely restructured in spite the fact that many states have these other carved and obsolete institutions that require this going from this to a constitutional point of view. People do not expect for their civil code to have a definition of marriage. People expect that if marriage is not described in the civil code, amparo is the system, the method for constitutional redress. So we understand how institutions through amparo are suffering or going through a paradigmatic change. So amparo is a good mirror for us to understand how we are doing as a constitutional right. Amparo has procedural restrictions. Who can file, uh, what is a legitimate interest, how amparo can adapt to human rights versus an unclear interest or systemic interest that we have, how amparo can have this concept of being efficacious, and how it can not deny a group of people the amparo protection is a going back. I think that amparo, apart from this historical evolution, is also beyond the actions and controversies, the main meter that can reflect the ideological understanding of our Mexican Constitution with the increasing participation of local courts for interpretation, but it still is the main engine or the main parameter for constitutional understanding. I'm willing to answer any questions. Thank you, Doctor.
Gracias, doctor Sosa. Adelante.
Thank you, Dr. Sosa. And Justice Gonzalez, the floor is yours. Thank you very much. I think it is a privilege for anyone in academia, and especially for a court officer, to have the opportunity to exchange points of view with university students and graduate students who are interested in a legal and diverse legal system, such as the Mexican system. I deeply appreciate the Dean's invitation that I received, and I want to thank Dr. Salazar, who is the director of our Legal Research Center. I want to thank James C. Rogers School and you graduate students who are taking this very important course of study. I have read a lot about the U of A. I understand the high level of the graduates who have made it to the Supreme Court of the United States and the academic exchange that you're having with our country that fortunately will enrich all of us on a cultural level that will expand our understanding of the U.S. legal system, a complex system. And we very much thank your interest in knowing from a real point of view, what is the legal situation in our country. I'm going to talk about two large topics. amparo and nuances within Mexican constitutional law, and the new reform that is being laid out, that even though it has been approved, it still would have to translate into new laws. Legal studies are lifelong studies. We start in school. Some people started earlier, maybe when they have some sort of legal problem, but it allows us to understand more clearly when we study and we exchange points of view. And these meetings between jurists from two countries help us a lot, are very helpful in us resolving our problems that we have every day. I have heard of interesting issues that happen with Mexican citizens traveling to the United States, the issues, and also US citizens who travel to Mexico and who are present in our country and who have a concept of law that is completely different. Like Dr. Fernando Sosa so well stated, and I appreciate his introduction, the amparo procedure is one of those mechanisms that has more permeated more deeply the Mexican legal culture. As many procedural instruments makes it is really a landmine field for lawyers. In personal terms, I firmly believe that this procedure is in fact a concentration of legal rituals that many times make it look like it is very far and removed from the people who go to justice for justice in our society. But please don't misunderstand me. I want to express an allegory of what should be understood about amparo. And I want to talk about the virtues of the amparo procedure in our country. For this reason, first of all, I will talk about certain procedural nuances, something about the rules, and also nooks and crannies that are hard to understand. I would like to offer two examples, two cases, and express how the amparo has served to, in a way, model the legal understanding, such as the right to education, and especially how a problem like this is a result within the indigenous country in our culture in our country. I remind you that in Mexico, there is a large indigenous population that has been ignored for many centuries uh, by the people who knew the laws and the rights. It is just the story here. This is a story of a specific case. It's a case from 2019. Later, I will have a brief abstract of what I'm talking about with some technical support. I will send it to you for distribution if anyone is interested in looking at the text that we're talking about in Spanish, written in Spanish. Take into account that the ability to go to justice, to take to justice the rights, the cultural rights, is one of the pillars of the job of a constitutional judge in our country. Its efficacy has to be the barometer that guides the rulings. And personally, since I joined the Supreme Court in our country, I have sought that they find in amparo a mechanism that uh, grants them, that supports the rights with different interpretation and maximize the effects and especially the scope of the protection. I start from the certainty that we cannot seek refuge in the comfort of old procedural interpretation and not look for other perspectives that will allow for people to find in amparo the most common procedure in our country that will consolidate its efficacy. I'm not going to talk about ideological issues of access to justice. I just want to share how this perspective that I am taking on, and I deeply believe is something that I have used as a constitutional judge. As constitutional judges, we also must seek that our rulings, in as much as possible, beyond our judgments and these events like the Arizona School of Law has given us a great opportunity. Therefore, to show how we have tried to reformulate the access to justice in our work, I want to talk about this judgment 115 in 2019, where I was the writer. This is a simple case that to some people is not important, but to others it is. A group of parents of indigenous children of the communities of San Jose in the municipality of Felipe Carrillo Puerto in the state of Quintana Roo, that's in where Cancun is, you probably are familiar with it, were impeaching some acts by the actions by the local authorities. The children were in early school. In our educational system, we have early schooling or the children through a certain age, and then there is pre-grade school, grade school, middle school, and so forth. Those children were in initial schooling. They're indigenous children whose parents, many of their parents do not speak Spanish, but indigenous languages. And these children were in this initial schooling in an Ignacio Dama, an indigenous school. The governor of the state gave directions to all the teachers to incorporate in the basic educational system because they didn't think it was the initial early schooling was not considered important or mandatory. This until when May 2012, the National Council of Education wanted to provide complementary resources to apply them to improve the development of education in our country. The problem with that decree is that it stressed that the educational authorities should give indigenous education only by CONAF. So the Department of Education withdrew the instructors that were trained in being teachers and had many years of experience. Those teachers were replaced by just one teacher who did not have enough training and especially not enough experience to adequately educate indigenous children. Additionally, this instructor, as it happens in the Mexican schooling system, did not attend school because he had a union permit. We know what those union permits mean for the educator unions. The parents were concerned, they were stressed, and they argued that that violated the children's best interest. It also violated the right to initial indigenous education, and it also violated the progressivity of human rights principle. Also, once the decree from March 22, 2012 was applied, the parents also uh, challenged several articles of that decree that had been published in February 1982 and had been modified in February 2012. This decree established the ability of CONAFE to receive resources and apply them to the development of education in our country. The argument was that this rule impacted the rights, and they also said they had not been consulted previously by the authority in accordance with the rights that indigenous communities in our country have to be consulted beforehand whenever someone in authority is going to take measures that affect the rights of the indigenous people. We needed to resolve a few procedural issues before we took on the case. First, that the collegiate court had asked the Supreme Court of Justice to uh, take their original jurisdiction over the case. This collegiate court thought that they did not have jurisdiction to decide the constitutionality of this decree. However, the truth is that the collegiate circuit courts do have the jurisdiction, and the court then should decide the issues on this decree and return this issue to the collegiate court for them to issue a judgment regarding the rest of the problem. However, we in Division 1 decided that we would take jurisdiction on the decree. And because the constitutionality of the challenged acts was subject to this validity, we concluded that it was necessary to take on the case to resolve the case completely, because the case had the setting of a criterion for that was important and relevant to the community, because we would have to interpret what initial or early education meant, and especially what indigenous education meant, and also how the progressivity principle would work uh, on vis-a-vis guaranteeing the children the right to education. So what I mentioned was the first procedural problem. Second, that the children were over 5 years old by the time the amparo was resolved, and early education was limited to children up to 4 years of age. So it looked like the case should have been dismissed, in that these were consummated facts that had been irreparably resolved. However, uh, from the time of the act that was challenged, this damage could be resolved if amparo was granted. So it would be possible to return to them the rights that had been um, denied. Um, the thing is that mandatory early education acquired the status of a constitutional obligation at the time of the issue. So it was necessary to question whether Division 1 of the Supreme Court could rule on the retroactive application of a constitutional reform. In this regard, the Supreme Court has held that the only constitutional system that can be used for constitutional control on an amparo case is the current law. So retroactivity did not hold, because the court should look at the problem in light of the current constitution at the time the amparo was ruled on. After these procedural issues were resolved, on writing our judgment, we thought it was necessary to respond first to the first main questions before looking at the problem that the parents were interested in. Number one, what is the constitutional standard of the right of children in indigenous right of to education in children in indigenous communities? And two, what is the constitutional standard of protection to the human right to consult indigenous communities? In answering the question, what is the standard on constitutional right to the right to education? First, we had to figure out 5 issues. Number one, to explain what was the doctrine of social rights, then to figure out what was the constitutional doctrine on the right of education, and the constitutional right on human rights for children. The fourth issue also implied developing a standard to protect education, to protect the right of education as part of the sphere of the undecidable. And the last one was to establish what was the content of the right to education on the members of the indigenous communities. I will explain now our answer to those issues, and I will explain them as questions so it's easier to follow the thinking. One, what is the Supreme Court's doctrine regarding the social rights? In principle, Division 1 has held that social rights have priority over the solidarity obligations that the state must fulfill. Their importance is in that they try to satisfy the basic need of every individual. Social rights, as we know, have a level of are not as specified as individual rights traditionally, but that does not exempt the right from the state from the obligation to promote, protect, respect, and especially to guarantee human rights that the Constitution, the Mexican Constitution, recognizes. Social rights are permanent. This implies that the laws have permanent legal positions that are not susceptible to restriction and that they force the legislator to not restrict them. This obligation also results in a duty to abstain in that the authorities should try to avoid getting involved in the exercise of those rights. Article 16 of the American Convention on Human Rights talks about the state's obligation to respect and guarantee the economic, social, and cultural rights. Also, this obligation is also in Article 1 of the Constitution of our country. This obligation, as we know, implies that the progressivity of the effectiveness of right has to be guaranteed. The resources that should be used, and also the duty to go to international assistance for economic assistance. Please switch to the German channel.
Consiste en la obligación estatal de avanzar hacia la plena efectividad de los derechos sociales y que también se traduce en la prohibición de regresividad. Las medidas
The
regresivas
measures, the regressive measures are those improve the rights of social rights. In the case that the state would use these regressive measures, it would be under the obligation to show that it has chosen that measure after an exhaustive analysis of every single possible alternative. The second component states that states are under the obligation to use these measures to guarantee social rights. Nevertheless, this has to do with most using the resources that these states would have, which is intimately related to the third component, that the state is under the obligation to ask for international assistance, be it technical or financial, to guarantee these social rights. Once we have these social rights components, we need to answer this question. What is the constitutional doctrine about human rights to education in our country? As we all know, human rights are recognized in the third article as well as the fourth article of our Constitution, as well as in diverse international instruments. For example, we have the 1969 Children's Rights Declaration that establishes that every child has the right to receive free and mandatory education, at least in primary educations. Therefore, the state has to provide an education that would help their general culture and would allow them to develop their aptitudes in having the same opportunities, an equal opportunity. Basic education should be oriented to allow autonomy of those who receive it, should be accessible to everyone without discrimination, and mandatory and universal. The Mexican Supreme Court has defined the right to education of the prerogative that every human being has to receive information, education, teaching, which is necessary to the development of all their capabilities, be it physically, human, intellectual. That right is translated in an obligation by the state referring to these actions that are guaranteed, and also in a negative way that identify with prohibitions towards authority that talk about not interfering to access to any educational. After establishing this constitutional doctrine about the right to education, we should answer the following question. What is the constitutional doctrine about human rights for children? The first court for this Supreme Court has been very emphatic, saying that we have obligations towards protecting children in accordance to Article 17 of Children's Rights Convention. In Mexico as a country has obligations that translate into supporting those educators, in this case also parents, so that children would develop a full development, which also implies to provide wholesome systems and develop programs for specific needs. Article 19 of the this convention also states this obligation by the states. The Inter-American Court has been emphatic as far as the obligation of different countries when it comes to children's human rights in situations of vulnerability. Therefore, they are victims of a double aggression. This is reinforced by the 1959 Children's Human Rights Declaration, where it establishes that children will have special protections, but also will have services and opportunities so that they be able to develop physically, morally, spiritually in a healthy manner in conditions of freedom and also dignity. Therefore, it is evident that there is a recognition of children's rights, which is part of a special protection. Special because of its particular vulnerability, and it implies additional steps by the government. Taking all of that into account, we could ask ourselves, what is the education standards for for rights? So coming to this point, once we determine what social rights imply and what is the scope of the rights to education and the rights that of children have a standard, a special standard, we should respond as to what is the specific standard for protection for the right to education. The Mexican Constitution, we included in May of 2019 the right to primary education as a human right and part of the content of compulsory education that the state is under the obligation to provide and to guarantee, in this case, that we define the education that minors receive from the time they're born and when they begin developing their first steps in education that are necessary for education within the family unit. It's clear that initial education had been included in the Constitution as a fundamental right and as part of that right to education, but nevertheless, it was necessary to develop a methodology to develop authorities that modify the protection of a human right. For that, it is necessary to first identify what is the nucleus of human rights? What is the essential element? that if we limit or restrict, it would lose the sense of its existence as a guarantee, as a right. And then we need to find where is human rights within our laws, meaning if it's part of the Constitution or is it supported by international treaties that we are part of as a country. We also have to identify who are the authorities in charge that would guarantee this right. So we would identify who has the right to affect these rights in a substantial manner. Before concluding, speaking of rights, we have to analyze the decisions and the rulings that would affect human rights. If this would be a negative ruling restricting rights or the exercise of this right, or if it's positive, it would imply that this measure maximizes the exercise of this right. And we need to take into account the nature of this measure. We would have to conclude that if it's a positive conclusion, well, that would mean that this is something decidable. And if it's negative, it would be considered as something that is not decidable, aside from the authority having being able to decide. So we conclude that the Mexican state has achieved a specific degree of protection to the right to education, including primary education. And this becomes something undecidable in regards to the right to education. So therefore, authorities have to avoid or issue in any type of rules that would diminish its protection or could be in contrast to that right. So if there is a law who would want to negatively affect the effect of this right within what is something that is undecidable, such measure should have to pass the test of the most strict test of proportionality. Finally, to answer the first main question that we ask ourselves, it is necessary to identify the following. What does the right to initial education mean within members of indigenous communities? According to the second and third article of the Mexican Constitution, the state is specifically under the obligation to guarantee and increase the levels of scholarity of these indigenous communities, favoring bilingual education and intercultural education. Conclusion of primary education, productive training, and especially middle and higher education, as well as to define and develop educational problems with regional content that would recognize and value their cultural heritage of these peoples. The court has established that the judicial position of these indigenous peoples are in the highest level, and the exercise of their rights, their individual identity and collective identity, as well as the need to increase the lack of equality in opportunities that affects them, are part of the objectives that were stated in our Constitution. For these reasons, also, the court recognized that the state is always under the obligation of adopting measures inclusively so that the members of these communities could continue having these rights, especially the right to education. So this human right to indigenous education should be satisfied with some additional guarantees to have it in their own and their languages, and also using their cultural methods of teaching, and third, as a reflection of their cultures and traditions and history and aspirations. So if the human right to education would not be satisfied with these additional guarantees, this would translate into a double vulnerability because it would only be against education rights and the right of education for indigenous peoples to receive their education according to their culture and in their language. After responding to the first question, in regards to this resolution, well, what is the standard, constitutional standard to human rights to initial education for children in indigenous communities? Well, we need to respond to the second question. What is the standard for constitutional protection for human rights to consultation to indigenous communities? This question is related directly to the concept of, well, violating the rights of parents and according to March 12, 2012 resolution, this had been applied without consulting these indigenous communities about their implementation. As is done in other countries in the world, in Mexico, the right to consultation to indigenous communities has been explored by our courts and has decided that all authorities within their scope are under the obligation to consult with them before adopting any action or any measure that could affect their rights or interests. This consultation that also has to comply with the following parameters. A, to be done with enough time before the beginning of execution, and B, culturally adequate through the representatives or traditional authorities, meaning according to their customs and traditions, and through the means and instruments that are ideal for those communities. C, it should be informed, meaning with the existence of a precise ways of information about the nature and consequences of these projects, but also should be done in good faith in the absence of any participation in the agents or its agents, the state, or that have been authorized. Also, the Supreme Court has established that the right for indigenous peoples have to be consulted is a necessary prerogative in order to protect the freedom of these peoples, and as well as their cultural rights and rights of patrimony. The court also decided in order to realize and to develop this consultation, the responsible authorities also have to be involved in the particular circumstances and analyze if this act can impact their conditions of life in the community, identifying if any of the following hypotheses would be updated because of the act that will affect them. There will be a loss of territory and traditional lands. Will they be able to will they have to leave their lands, or is it possible that they would have to be moved forth? The necessary resources for their physical well-being will be destroyed. How about the environmental objects, the negative impacts, sanitary and health and educational, etc. So now we define the applicable doctrine and methodology to this case according to the questions previously stated. We would have to solve the issue. Parents, as you may remember, stated that the measure taken by the authorities in regards to replacing the teachers, being that CONAFE was in charge of implementing these educational programs, what they had done, and what had happened was that children did not have classes, and when they did, a person was teaching who was not qualified to do so. This argument, in accordance to what we earlier said, had based on the formal education rights and is part of the general social rights, which implies that there is a positive obligation by the state to guarantee it and thus adopt the appropriate measures and legislative measures in order for them to be achieved. Not only that, but also we have once recognizing the state, that the right of the state, and it has to be done as quickly as possible. So therefore, any other measures that could represent uh, negativity in its exercise should not be used, meaning it is forbidden to take measures that could worsen the levels of their rights. Once the Mexican state has recognized the human right to education, and not only that, but trying to comply with the principle of progressivity of societies, we have reinforced the necessary guarantees in regards to children and specifically members of indigenous communities. It is not possible for these protection to be diminished or to be deteriorated. Once we apply the methodology stated previously in regards to how to identify what is undecidable in respect to a specific human right, it is possible to come to the following conclusions in regards to the nucleus of what human rights to education is. We recognize that these children had achieved a specific degree of protection in regards to protection of the law of the rights. There is a constitutional range, and also stated in multiple international treaties. Authorities are who guarantee these rights are every authority at a national and local level, including the Department of Public Education, CONAFE, and the governor of the state of Quintana Roo. From the analysis of this ruling, we can come to a negative issue, whereas institutions of authority were translated in a substantial restriction in exercising rights to indigenous education, whereas the decision of these authorities would imply that children would suffer the detriment to their quality of their education. So coming to the conclusion that affecting human rights to education has been negative, this is a human right where it is including within the sphere of what is undecidable. So therefore, we recognize that children in the municipality of Felipe Carrillo Puerto had already achieved a specific degree of human rights to education, being that from initial education and such content is within the sphere of is what is undecidable, and the responsible authorities should have stated or are ruled about the protection achieved, not only positive but negative issues, and also making sure that any act could be performed that could represent a diminishment in the degree of protection. As a last point, in conclusion, the argument of these parents in regards to this February 11th, 1982 decree was unconstitutional because they had not been consulted previously. Whereas this happened because this was an act of authorities that would directly affect their interests, specifically their right to receive education in accordance to their language and in accordance to their cultural criteria, and therefore should have been consulted previously in order to execute it later on. This means that previous to this legislation, there should have been a consultation as to their implementation to indigenous communities where these parents belong to, meaning that they could manifest and have their opine about the changes that would happen in order to guarantee the human right to initial education, and also knowing and identifying that this would affect their interests, whatever they would be. Because as I explained earlier, If the state has the intention to execute a program or implement a legislative measure that could affect the interests and the protection of a collective and exercise the right of a community, a tribal or indigenous community, first of all, to comply with their constitutional and conventional obligation to consult according to the terms established by the Supreme Court. And for this, we stated the amparo so that the responsible authorities would adopt the necessary measure to guarantee children their right to receive a bilingual education in Spanish and their indigenous dialect, and also be educated according to the values of their community, and also any other act that could represent an impact to their children interested to be forbidden, and previously always consult with them in order to guarantee their rights. The 2008 amparo in regards to indigenous communities from the Supreme Court states how we can understand this as becomes a fundamental element to guarantee the rights of these Latin American nations. As we specifically guarantee this, this is a very sensible, is important task for any constitutional court, because undoubtedly this would have an effect in the efficacy of traditional courts in our regards to our indigenous times. This is regards to the 2018 amparo. Now we shall go to the English, please. English channel.
Este surge de una solicitud de ejercicio de facultad de atracción para que la Corte resolviera un conflicto entre las autoridades municipales de una comunidad indígena y un miembro de la misma. El problema jurídico a resolver era respecto a si la Sala de Justicia Indígena del Tribunal Superior de Justicia de Oaxaca era competente para conocer de este conflicto al interior de la comunidad. En la ponencia que tuvimos la fortuna de redactar el proyecto de sentencia que fue sometido a la consideración de mis pares. Voy a exponerles brevemente de qué se trató el caso y, sobre todo, qué resolvimos. El problema aconteció en el municipio de San Cristóbal, Suchitlahuaca, Oaxaca.
Sorry.
Se trata
The problem happened in Oaxaca, a indigenous community that lives in that town that is near an area that has been reforested, and it is a Palo Sol area that where people have no access. The neighbors filed a complaint, and then the local authorities found a gentleman who had 50 goats, and he was causing damages on that land. The the town council decided to fine him 2,000 pesos, and he was told that if he were to do it again, they would report him to the Environmental Protection Agency, because he was violating this area. And then Mr. Eduardo's wife, Beatriz, and her daughter were found in the same area, shepherding near close to 100 goats. It started out with 50 and then 100. The lady insulted the representative of the town, and she was fined again 2,000 pesos. Due to her continuous verbal assaults, the local authorities decided to arrest her for 24 hours per the rules of their own community. 5 days after the lady was arrested, some other residents went to the local authorities saying that Palo Solo area had around 100 goats roaming on their own, and these goats were Senor Eduardo's. So the municipal authorities got the animals and kept them in the municipal yard. They decided to charge 5 pesos a day for each goat that would spend each day at the yard, and also a fine of 500 pesos for every tree that was damaged. The assembly called Mr. Eduardo and Beatriz to fulfill their obligations, and should they fail to appear, then they would sell the animals for the appropriate amount. As expected, the couple failed to appear. Along the same lines, Beatriz, the wife, went and reported to the prosecutor's office, and then the husband also joined in that report against the municipal authorities for abuse of authority, for restricting their freedom, for burglary, and whatever other offenses that would derive from their actions. The prosecutor started an investigation against the authorities of the municipality. And then the magistrate judge in Nochistlán, Oaxaca, requested that that the city be charged and notified of it. On the other hand, on the indigenous justice and Division 5 of the Court of Oaxaca, Division 2 of Indigenous Court ordered the magistrate judge to dismiss the case against the municipal authorities, and for the sanctions against Eduardo should be filed, should be studied again to find for him to be able to repair the damage that he caused. Eduardo disagreed, and he went on amparo directo against the indigenous court. What he was saying is that the indigenous court and the superior court in Oaxaca did not have jurisdiction to hear the case because of time and the subject of the matter. And also, if they had jurisdiction, they erred in that they should have not agreed with the local authorities' decision because the rules were not valid. On the other hand, the municipal authority asked the court to join in the amparo and resolve the legal problem of the jurisdiction of the indigenous court and the validity of the legal of the enacted laws. The court joined the cases, and then it was brought to our court for consideration. Eduardo, in the amparo, the questions that the Division 1 had to solve were: one, does the indigenous court lack jurisdiction because of time and subject matter to hear the case that was heard by the indigenous community? Was it right for the indigenous court to consider that what was adjudged by the indigenous community went to the indigenous court? It was a very relevant resolution from a legal standpoint because Division 1 had many precedent regarding the constitutional Article 2, but there was no precedent on the issues that had been ruled on in the indigenous jurisdiction. Division 1 had to set a standard to determine when you are in a case where the indigenous court has jurisdiction or the ordinary courts of the state have jurisdiction. Article 2, Section A, paragraph 8 establishes that at the moment, at the time that the indigenous people are under state jurisdiction, their customs have to be taken into account and their diverse culture. This is called intercultural perspective, meaning that the analysis has to be undertaken under a sensible interpretation of the issues at hand and the rules that will be applied. To undertake the analysis, the judgment had 5 points. One, the constitutional and international obligations of the Mexican country on indigenous jurisdiction. Two, how the jurisdiction of the court on time and subject matter of the trial. Three, the factors that should be considered by the court to determine that the cases they hear are or are not under indigenous jurisdiction. 4, the interpretative principles that rule the indigenous jurisdiction. And 5, the limits of the indigenous court or justice. Regarding the first issue, the Constitution establishes that it is the obligation of the Mexican country to have mechanisms that would recognize the old-time indigenous community courts. Therefore, the mechanisms for the state authorities to recognize the validity of the rulings of the indigenous courts and for those to be efficacious. We have to explain the difference between ordinary jurisdiction and indigenous jurisdiction. Ordinary is exercised by the central state that has the authority to administer justice and hear civil, criminal, family, administrative cases, etc. Regarding the special indigenous jurisdiction, it is that where the authorities of the towns or indigenous community have the ability to resolve conflicts within their communities in accordance to their customs, as long as they are not against the Constitution or the international treaties on human rights. The indigenous groups have a right to have this indigenous jurisdiction. It is a consequence of the autonomy that the Constitution gives them to resolve their internal conflicts per their vision of the world and their understanding of the rights and how these rights should be protected to assure that the community remains in existence. It breaks the monopoly of the central state on the administration of justice. This perspective, based on legal pluralism, allows different systems of laws to coexist in our country. On the one hand, there is the laws that are in the books and indigenous rights, indigenous law on the other side. Particularly in the state of Oaxaca, that in its local constitution, because of their multicultural aspect and the presence and diversity of many peoples and indigenous community that form the state of Oaxaca. Taking this in mind, the Superior Court of the state created a division for indigenous justice that has the ability to adapt the rulings on indigenous court with the existing other rules. Also, the jurisdiction, regarding the jurisdiction, Eduardo said that that court did not have jurisdiction to hear the case because the court was created after the facts that originally caused the conflict. Division 1 of Superior Court ruled that Eduardo was not right. To resolve this, the judgment bore the retroactivity principle of the Supreme Court on procedural rules, taking into account that the procedure would actualize in phases, and it could be that two rules are in the same procedure without prejudice to the prior rules when the new rule comes into effect that took into along with the old rule, because the acts that form the procedure go according to phases in the procedure that are ruled by the current rules. That, and because the indigenous division only has jurisdiction to agree or not agree with the rules, the rulings of the communities, it is possible that the division had authority to validate the municipal rulings. And also it did take place in accordance with the Mexican rules, according to the Mexican Constitution and according to international treaties that are signed by the Mexican country. From there, the indigenous communities have the jurisdiction to hear cases that happen within their territory. So the special indigenous division has the authority to ratify these cases for them to have effect against the central authority. And this is according to the organizational judicial law for the state of Oaxaca. The judgment states that the special jurisdiction, which is called fuero indígena, is a way to preserve in an ethnic and cultural way the indigenous people. The way this mechanism contributes to conserve their customs, their values, and their indigenous institutions to use these practices that identify them as such as a nation. Is a right that the communities have to be judged and also to resolve their conflicts on an issue. The next step regarding Senor Eduardo was to determine the third point. What are the factors that the courts have to take into account to determine that the hearing of certain facts are the subject of special indigenous jurisdiction? For that, we needed to go to the doctrine that Latin American courts had issued regarding this issue. And we found in Peru, Colombia, and Bolivia facts. Taking into account this in legal dialogue with these countries, and Division 1 ruled that there are 4 standards or 4 criteria: personal, land, institutional. The personal factor has to do with the court has to analyze whether the person that a fact is attributed to or even a crime belongs or not to a community or an indigenous community. It is important to see if all the parties belong or not belong to the community. If the person is indigenous and they are only sanctioned by the ordinary jurisdiction, it is important to know if the person understood the facts that are used against him, and that is a factor that should be taken into account when it comes to judging the responsibility. If the conduct of the indigenous person is punishable on indigenous and ordinary jurisdiction, the court has to take into account the ethnic conscience of the person, their degree of isolation in the culture where they belong, as well as their knowledge of their acts and their acts constituting a crime or not. And this is to determine if the person should be judged by the national system or if it's the community who should judge and issue sanctions as expressed in the Constitution. In short, the 3 relevant factors in this point that the court needs to determine are: what are the customs involved? What is the degree of isolation of this indigenous community versus the other community? And what is the individual's position vis-a-vis a sanction? Now, if the case happens between an indigenous person and a non-indigenous person, the other factors will determine what is the correct jurisdiction. The territorial factor means that the court needs to assess whether the events that happened within the indigenous community are subject to being analyzed. This standard doesn't have to do necessarily with the land they occupied, but the territory that traditionally they had access to for their activities and all the subsistence activities. That is the scope where in the area where all the communities, the indigenous communities have their culture, and it is not limited to the geographic boundaries of their territory. The objective factor is the third element that the courts need to examine, and it consists of evaluating what is the legal right that has been impacted, and is it related to a special interest of that indigenous community or a member of it? In this regard, there are three suppositions. One, that the legal right belongs only to the indigenous community. Two, that the legal right or the person injured or harmed belongs to the central state. And three, regardless of who has the right that an issue, if whether the person belongs to the indigenous community and the majority of the community. The first point has to do with indigenous jurisdiction. The second one to ordinary jurisdiction of the central state. Regarding the third point, the element is not determined to define the jurisdiction, and the other factors should be taken into account. The last point of the institutional factor is that the court has to study the existence of authorities and habits and customs and the traditional procedures in the community. The court has to verify that this habitual or this, I don't know what it's called, customs exist. This is a factor that is important to avoid tension between both jurisdictions when there is a conflict between the individual rights of the members of the community and the acknowledgement of the ethnic and cultural diversity of the people. Per each particular case, the court has to take three factors when they evaluate the factor. One, the existence of habits and norms. Two, they have to look after the conservation of ancestral customs and habits of each community, specifically regarding the mechanisms for resolving conflicts, internal conflicts. Second, they have to look after the rights of the victims, for the judge to be able to, the court to be able to study all these factors. Division 1 established some precedents that they have to go to all the legal means like experts, anthropologists, etc., for to assess the culture that it has a dispute. And there should be an intercultural perspective and a minimum consensus on the laws applied. Once the judge's position regarding a case is established, the thing was to define what are the principles or criteria of interpretation that rule this interpretation. There were three in Division 1. The greater autonomy of in the communities, the limit of the human rights in the Constitution, and the principle of maximizing the indigenous autonomy from restrictions. The first means that the interpretation standard seeks more autonomy for the indigenous people. The second one provides that the indigenous rights have as limit, the boundaries are the human rights. And the third one is that habits and customs of the indigenous people prevail over the other rules. This will privilege the administration of justice. The judgment, after clearing this point, we try to figure out what the limits of the indigenous jurisdiction. We said the limits of jurisdiction of the indigenous jurisdiction, and we stated that the only limit of the non-applicability of indigenous right is if the customs of the people are in direct violation of human rights, such as torture, um, killing people by force, slavery, discrimination, and rules that eliminate the members' access to justice. So if any of these events happen, then the special indigenous jurisdiction would not have jurisdiction over the issue. This because the application of ancestral customs of the indigenous people and their rules cannot be an excuse to intensify oppression within the communities, especially of the members that traditionally are excluded, such as women, girls, or boys, or the disabled. However, it is possible to restrict some rights. This is when their exercise, their full exercise can put at risk the community or the preservation of their habits. For instance, the right to collective property. The court needs to weigh whether this restriction has an objective or purpose, if this measure is necessary in a democratic community, is it adequate, and is it proportional for the ends that it seeks. An analysis of this sort has to be undertaken without uh, uh, without affecting the uh, ancestral customs. In the case of Senor Eduardo and the goats, all the factors that I mentioned occurred. Both the municipal authorities and Eduardo and his wife Beatriz belonged to an indigenous community. Second, Palo Solo, that is an area that is within a territory of the community of San Cristobal Xochitl in Oaxaca. And third, the destruction of the area that was reforested is a right that the community has the right to protect. And also the institutional factor comes into play because the indigenous community has authority and mechanism on their ancestral uses and customs. So it was clear that the community sanctioned Eduardo and his wife in accordance with the municipal rules of San Cristobal. Also, in the case at hand, there was no limit to the special indigenous jurisdiction, because in this dispute, the indigenous communities did not impose any sanction that violated any rule. So Division 1 concluded that the indigenous court in the Division for Indigenous Court in the Court of Oaxaca had acted correctly in determining that the facts presented did belong to the indigenous jurisdiction. So we denied the amparo presented by Eduardo and his wife. Lastly, we concluded that the court had acted correctly in declaring that the prosecutor's office should dismiss the criminal case. And we also specified that the prosecutor's office should be aware of the authority that the communities, the indigenous community have to resolve their internal conflicts. The relevance of this constitutional doctrine lies in that it seeks that the judges and magistrates throughout the country have clear and precise criteria that they can go to when they need to decide whether who has jurisdiction over a case, the indigenous court or the ordinary courts. Also, we're seeking to eliminate the legal uncertainty in our country in that regard. And we were able to give more legal certainty, not only to the authorities of the central authority, but also to the members of the indigenous community. With this judgment, the Supreme Court recognized not only the enormous historical debt that the Mexican government has to the original indigenous people in their community, but it also sent a message to the indigenous communities that their demands for autonomy have been heard, and that they do have the right to resolve their conflicts without being penalized by the authorities of the central state.
Aún falta mucho para erradicar los
And
problemas de
even though we still have a long ways to go to eradicate the problems that come from the diversity in our country, this sentence is a step, a small but firm step in that direction. Going forward, the demands for free determination and autonomy are in the hands of the indigenous community. And therefore, our work as court is not to ignore the demands of the indigenous people or communities in their being recognized, in their having a recognized right to apply their laws in the resolution of internal conflicts. Each one of us, from the trenches, from our own trenches, be it academia or the courts, and thinking of our rule to safeguard the human rights and the international treaties in the subject, we all have the obligation to guarantee the dignity of the indigenous communities and their members. The third topic we have to talk about is the legal reform that Dr. Vega talked about, and I'll be happy to talk about, and then you can ask me, and please go to the German channel. Oh, wait, 5-minute break.
Perdón, gracias, ministro. O podemos, ¿quieren hacer un receso o podemos abrirlo a preguntas antes del tercer tema? ¿Cómo se siente más cómodo, señor ministro? Y también
yo atendiéndolos a ustedes. Como ustedes
Justice Gonzalez, what would you do? Whatever you are used to, I remember a phrase. Thank God it's Friday, TGIF, and it's time to try the beer and go dancing. Well, with COVID, it's a little harder now. As law students, you also, I'm worried that your human rights have been violated with this presentation by Dr. Vega when he had you listen to us today. But we said that we were very happy to be here. But then you can also sue him for whatever traumas you will get from spending this afternoon, the last afternoon in the month of January 2021, of being in class. But I will try to answer your questions. Thank you very much, Teresa and Ruben. What do you think? Should we open it the floor to questions? Ruben, you are the moderator, or if anyone is interested, or we can take a break and then go talk about the reform on the of the court system. I don't know if there are any questions on the subjects that we talked about, or we can have a recess and then move on to the next topic. I don't know what Justice Gonzalez wants. Sure. How much of a break do you usually take? 5 to 10 minutes or so? Okay, 10 minutes. And they were on the German channel. In Germany, classes always start 15 minutes late. So the teachers can have their last beer before they start the class. So the students do too, which I found quite surprising in German universities. And also American universities have alcohol. And that's what distinguished business school from law schools. At law schools, the cafeterias had beer and Coca-Cola or Pepsi or one of those brands, whereas business school had champagne, French wines. It was a different environment. Well, a glass of water is good. Okay, 10 minutes. So we'll come back at a quarter of 4.